Welcome to The Law Matters. Of course it does. Hi, I'm Debbie Moraes, your host and moderator. This program, as we tell you, has been created to educate, inform, and help you with law matters because the law matters. Understand the law better, and you're in a better position to understand how to better protect your family, yourself, your business. We provide information and resources that will help you determine whether you need or want to contact a lawyer. Perhaps will help you determine that you may be able to handle some issues yourself. If you do decide that you need outside counsel, you'll be better prepared, and as a result, so will the professionals who you select. Our goal, of course, is to save you time, money, and of course to achieve the best possible results. We want to thank and welcome, as usual, David Bazar and his law firm, the Bazar & Associates Law Firm in East Providence.
Thank you.
Thanks for being with us. So, there are legal lessons to be learned in the Taylor Swift Groping case. That case prompted many businesses to revisit conversations and policies regarding sexual harassment, even slander, battery, and the rest. So today we'll talk about civil and criminal issues, timely lessons for businesses, workers, HR people, and the rest. As we say, our goal is to help you avoid those kinds of situations. So, I guess, David, many weren't surprised at how quickly the verdict came down that that sexual assault case in Denver involving that radio host had actually groped Miss Swift. Interestingly enough, he had done this apparently while he was standing beside his wife, another issue. But at this point, we should say there were no other coworkers involved. So let's talk about the case, the pluses and the minuses, and I think at some point, maybe it'll help others understand what really makes a good case or not. So, whether you like Taylor Swift or not, some people may not like her music, but she has not, up until this point, ever reported any kind of sexual harassment. She doesn't cry wolf or anything like that. They say that that speaks to someone's credibility. What are your thoughts about that, David?
So I guess lately you could say our shows have been ripped from the headlines.
Yes.
And when you take a look at this case, it really speaks to why someone would bring a case like this, because there doesn't seem to have been a lot of evidence on the side of the disc jockey or whatever he was, the fellow who brought the case. Yes. Against Taylor Swift. And remember, he's the one who brought the case.
Yes.
She didn't bring the case.
Yes.
And when I say rip from the headlines, the only thing I can think of is why would he bring a case like this where the evidence is stacked against him? As you say, her credibility is sort of impeachable in the sense that she never ever claims these things have happened in the past and doesn't cry wolf, as you say. So why would you do that? The only thing I can think of is for publicity. And so we ripped it from the headlines because it made headlines, and of course it's going to make headlines because it involves Taylor Swift. And clearly you would think that's the only legitimate reason, or not legitimate, but the only reason he would even try to bring a case like this.
Yes, so he claimed that there was defamation. It was because of what happened that he lost his job. Well, maybe, maybe not, but certainly when he comes back and said that he was defamed, and there are photos and the rest, I think we then hear later on, if you keep changing your story, maybe that's not a good idea. So if someone's involved in a sexual harassment suit and they apologize and then they don't, what does that say from a legal standpoint if you see someone responding that way? What does that do to their credibility or the case?
So remember, his case is the defamation
Yes.
case. And his case is based on a claim that Taylor Swift said something that wasn't true.
And that the mother said, had him fired, called the station.
Right.
And the security guard too, I believe.
That's the claim. And so the jury's verdict seems to indicate that none of that was ever even true, or at least it wasn't anything that could be proven in a case. And it's a civil case, so it's not by, beyond reasonable doubt, it's a preponderance of the evidence. And so given what I know about the case, which is only from the papers, I don't know it intimately or personally and haven't looked at any of the filings in the case, but from what I can gather from the case, so we can speak about this in generalities, is that there was no real evidence on his side for his defamation case. From the sexual harassment point, that would have been Taylor Swift's claim against him. And again, what makes it credible is that she does not bring cases like this with a regular basis or do things like this certainly for publicity, but rather she was responding to something that was brought against her, and she wasn't really asking for damages, money. She just was trying to prove a point, so to speak, and it was brought for that purpose and because he brought his claim in the first instance.
If you're working with someone and you are thinking that you're groped, a woman feels that she's groped, is that considered to be a criminal complaint? She did not. They stated Taylor Swift did not come back with a criminal complaint. Would that have been in other
could have
cases?
been.
Sure.
It could have been, and certainly there could have been in any type of case where there's unwanted touching.
Yes.
A case brought. It's an assault, and depending on how it's done, it could be a sexual assault. Oftentimes in a workplace setting, there aren't criminal charges brought because what you're really concerned about is the workplace and dealing with that issue and the environment you're working in and trying to fix that. So oftentimes, most times I would suggest there's probably not a criminal case brought. It could be, and it could have been in that particular case as well.
I think we should visit that a little bit later in that workplace situation, because I think you can extrapolate a lot from it. One of the questions that came up, considering that she didn't ask for, as you say, damages, she said $1, that's more symbolic than it is a
Right.
financial reparation. Does that make her story more compelling? Because number one, even if she wanted to sue for money, how much would that man have? Probably very little, if any. But the fact that she only asked for $1, how does that weigh on a judge or a jury's sensibility of the case?
I think in many ways it's a good legal strategy given the situation she was in. Again, she would have never brought that case had it not been for the fact that he brought a case against her. It wouldn't have been worth her time, her money, or her effort. In this particular case, though, she had to defend what was brought against her. So since this was brought against her, part of her defense is, wait a minute, this is what you did to me, so bring the case. And I think it does play well. Now, I don't know what the judge did or did not tell the jury as far as what she was asking for damages, but it certainly plays well, especially in the media, when what she's really doing is doing it for symbolic reasons. She's not trying to get money from him, she's trying to prove a point, and that's a good way to do it.
Address, if you will, the reaction time of what went on here. So we know that he's the one who initiated the lawsuit, not she who was the groped, rather than the gropee. But meanwhile, you always say that it's so important to document or to let someone know. Apparently, even though she didn't state a case or make a claim, she did, in fact, say something to mom or to that security person who then apparently ushered it through to the station manager and whatnot. So if you are thinking that you are likely to have a case, or maybe you don't have a case, but you just know this is a wrong, what do you say about how she chose to acknowledge that it happened?
I think she acknowledged it appropriately. I don't think in her mind it was worth raising to the level of a criminal complaint. I think the complaint that was lodged by her and her family or people around her was the way you let the station that this person works for know. What the station chooses to do with that is really out of her hands at that point. If they say this is an incident that rises to a level that they think they need to terminate their employee, that's their decision. And it's not as if, as I understand it, it was passed along to the station from Taylor Swift or her people saying, this is what we want you to do and you have to do this. I don't think that at all happened, and if it did, it would have been something that would have come out more publicly in the trial. So if what she did was to say, this is what happened, and she passed it to the people that she thought needed to know that, and they chose to pass it up the ladder, so to speak, to the people who this person worked for, then that's an appropriate way to handle that type of situation.
And we all know that she didn't exactly haul off and smack this guy in the middle of that meet and greet, which is the setting in which
Right.
it happened. But when she told mom, and this is not a minor, she's above 21 now, her mom calls the station or notifies this, and the security guard notices. What do you think about having someone else report that this happened? She might have written it down in a journal, as you would say, document something, what happened, how you felt, the circumstances. She tells mom. Mom calls the station. Is that a reasonable thing to do if you're working with cohorts and various vendors or suppliers in the workforce?
It's a good question. It depends a little bit on the relationship. Is mom just mom, or does mom have some professional relationship with her too? What if she didn't tell mom, she told, if she has an agent, her agent, or her security people, or somebody that works for her, and they passed it along? We wouldn't even be having that discussion as to whether or not it was appropriate for, say, her communication person to say, by the way, I arranged this situation, I arranged this meeting. That's what I do for, I'm her publicity person for Taylor. And one of the things you need to know is if you ever do this again with her or anyone else, this is what happened, and I'm passing that information along to you. Wouldn't even be a question. So I don't know if her mom has that type of relationship with her as well as being her mom.
Of course, in terms of evidence too, even if mom hadn't called and said my daughter was groped, or my client, my daughter was groped, there are paparazzi snapping everywhere, every second that she moves. So of course, some of them had photos that showed the exact placement of his hand at said time in question. So that, knowing that there was that kind of evidence, it's kind of interesting too that David would, David, not you, David, the person who was the talk show or the radio host, that he would be back and forth and saying that he didn't do it and he did do it, when he too knew that the whole purpose of the meet and greet was photos. How could you ever deny it? Whether Taylor's mom went to the station and said, Mr. Station Manager, do you know what happened? How could he even be involved with an occasion of thinking that he could get away with that?
Yeah, so I guess from the little I do know about it is it's his position that the picture doesn't tell the whole story, and there's things that aren't really explained by the pictures themselves, and you need to know more about what happened, and it's evidence beyond just the pictures. But as we can tell by the verdict, that's probably not really the case, and even if it is, from what I've been able to gather from the news, if I were an attorney and he came to me with that story, it's probably not a case I would have taken or brought.
Because? Because
there's too much information on the other side which is unexplainable or can't be explained away. And as you said, you didn't say it, but pictures speak 1,000 words. Those words really outweigh whatever explanation you may have, in my opinion, in that particular case.
So would you still think that way if you were told by the radio host that he accidentally, but he did have information on his computer, he spilled coffee on it, he said. Spilled coffee on the computer where he stored secret recording of a conversation with his employer about the allegations. So if you heard that, might you think, gee, this man really does have some corroborating evidence to support his case? Or would you say, this man's tampering with this, he's trying to play this a little bit more than he should? Would that make you think this is just not a good client, period?
If he had actual evidence that showed something other than what came out, which is there was an acknowledgement somewhere that the picture shows my hand somewhere where it doesn't belong, but it was an accident, and everyone acknowledged at the time, oh, that was an accident. And I had a conversation with my boss, which I have a recording of, which he says, yes, we know it wasn't what they said happened, but we're going to let you go anyway. Well, first of all, maybe the claim should have been brought against the radio station, not Taylor Swift, and the nexus to his losing his job in what she did and what her mom may or may not have done was so tenuous that even that in and of itself, to me, would have been raised issues as to whether I would have wanted to bring the case against them.
against them.
Do you have a case against your station for letting you go inappropriately? That's a different story.
And of course, David, this radio person, says that Taylor Swift interfered with his losing his job and for the rest of his career, which is part of what that lawsuit was about. Damages, I'll never work again, you've just maligned my everything that mattered to me. As it panned out, the judge did take Taylor Swift off of that lawsuit, saying that she had nothing to do with it. But still in question was, at least at some point, going to the jury, not to the judge, would the mother and that security person be considered to be unduly influential in how that case worked. So does it make sense that he has a defamation suit, if not against Taylor, maybe a separate one, or some rights of claim against the mother?
But didn't he bring that against her,
Yes,
and the jury found,
yes.
and the security guard?
And the mother, yes.
Yeah,
So they're saying no to
right.
Taylor. Judge
Yep.
said,
The judge said
take her
there's
off.
no evidence that she did anything here, so he, as a matter of law, said that claim is not going to the jury. End of the case as far as it goes against Taylor Swift. As far as the other claims went, the judge let those go to the jury, and the jury decided there was no claim against them, or he didn't prove a claim against them, and therefore those cases were dismissed as well.
And also they said that the mother did have a right. Andrea Swift, I don't remember saying that it was the mother had the right, but Andrea Swift had the right to make a call to the station if that's
Right.
what she felt she wanted to do. Explain the difference between the judge who's making a decision and a possible jury that's making a decision.
So
How does that play out?
In a jury trial, the plaintiff presents his or her case, and then at the end of that case, the defense lawyer can say to the judge that, remember the role of the jury versus the judge. The jury decides facts and then applies the facts to the law. The judge tells the jury what the law is and applies the law to the case. So at the end of the plaintiff's case, the defense lawyer can say to the judge, as a matter of law, they haven't proven a case against X, Y, or Z. So using this case as an example, if there's a defamation claim against Taylor Swift and against the mom and against a security guard, say, and at the end of the case, the lawyer for each of those defendants can say the plaintiff did not prove the case against his defendant. So the judge then looks at the law, and in the particular case of Taylor Swift might say there are no facts under any circumstance taken in the light most favorable to the plaintiff that would sustain a claim of defamation against Taylor Swift. For example, Taylor Swift never reported this charge, never said anything about him, and there's no facts presented in the case that she even acknowledged, I'm just making this up, that he did anything. So the judge can look at that and say, as a matter of law, they have not proven a case against her, and therefore I'm dismissing it at this stage of the case. As to the other two defendants, the judge might say, well, there are some factual issues for the jury to decide whether or not they said things that weren't true. They gave a report that was misleading, or whatever facts there may have been put into evidence by the plaintiff that the jury could consider to decide whether or not those facts make a claim under the law as the judge gives them the law. So in that particular case, say the judge says, nope, I'm not deciding as a matter of law that those cases haven't been proved, so the case will continue against them and eventually go to the jury for deliberation to decide whether or not the plaintiff met his burden of proof.
And if it weren't such a high-profile case, if it were initially a defamation case, would this have a similar scenario with a judge and the same kind of thing playing out with a jury?
All civil juries sort of proceed along the same way. So if I have an auto accident case, and we'll make one up that I would never take. My client rear-ended somebody and got hurt, and we present the case to the jury. Before the defense even has to prove its case, at the end of my case, the defense could get up and say to the judge, as a matter of law, the plaintiff did not prove that the defendant did anything negligent, taking all the facts in the light most favorable to the plaintiff. He still doesn't have a case because it was his negligence that caused the accident, not my client's negligence, and therefore the case should be dismissed. Almost every civil case, at some point in time after a plaintiff finishes, the defense will usually raise that motion to have the case dismissed based on the failure to prove a case by the plaintiff. In most cases, there's enough evidence for a judge to say, no, not at this stage, we're going to let the case continue.
So would there have been some wisdom in either Mueller's lawyer, David Mueller's lawyer, or even David Mueller himself saying, I think the one we need to sue is the station for ruining my reputation because they fired me on the spot and now I'm never going to be hired again in the workplace. Was there something to be said for that?
Yeah, well, that's why at the beginning I was saying, if the case was about a wrongful termination, it was the station that terminated him. And remember, we spoke a little bit about employment and situations on prior shows, and it's not my area of expertise, it's not something that I do, but from what I know about those particular cases, if the station fired him wrongfully, that's where his claim belonged. But I kind of think there would have been much less publicity for a simple case like that. As a, although there are some Taylor Swift overtones to it, it doesn't bring the notoriety that he got from bringing the case against Taylor Swift. And that's why I said at the beginning, ripped from the headlines. I think it was the headlines he was looking for.
Sounds right. And for other people in the workplace who have a complaint about being fired wrongfully because of defamation, slander, how much proof do you actually need? We talked about some supportive evidence in Taylor Swift's case. What kind of evidence supports defamation? Hearsay, if you hear people saying terrible things that then lead to your firing, is that documentable and submittable evidence?
So not usually in and of itself, just that. You need actual proof of some action taken by your employer against you that is not protected. As we talked about before, if you're an employee at will, an employer can let you go for really no reason. What they can't do is let you go for a reason that's protected. So if this particular, it was Colorado, I think you said?
Denver.
Yeah. So if the law in Colorado is that an employer cannot let an employee go based on false accusations, and he's claiming there were false accusations and they didn't give him his right to a hearing, a process, due process under the law that he may or may not be entitled to under his employment situation, or if he had a contract of employment, many times in that workplace they'll have employment contracts. If they didn't, the employer followed the rules of whatever his employment agreement called for, that would have been his claim. I don't know whether he had an employment agreement. I don't know what the rules are in Denver, but if he was wrongfully terminated, it's the employer that's responsible, not the person who says, hey, he did this to me.
Okay, and if it were a sexual harassment claim or assault or harassment, well, they're two different things, obviously, and the degree of severity differs greatly. You might want to address that. How does that play out in the workplace in terms of what needs to be done and documented?
So now you have a different situation. If he had a co-employee making a claim against him, or if the claim is the co-employee's claim for the sexual harassment, totally different case, different situation.
Yes.
That employee who is being harassed, and you said assault, which is, a touching that's not wanted, unnecessary and unwanted, then as opposed to something sexual in nature. Either way, if the employer doesn't do something to stop that, the person who is being inappropriately touched or in an environment that he or she doesn't want to be in has a claim against not only the co-employee who's doing that stuff, but really against the employer, which is really where the claim lies for not taking steps to protect that employee.
So if you happen to be the quote-unquote victim in this situation of sexual harassment or sexual abuse or battery of some sort. Obviously, you document it. What can you actually document? What someone might say if it's harassment, but if it's abuse, maybe you've had rape kits and those kinds of things. But other than that, which is more cut and dried, how does one reasonably build a case? And is it really to be a case if you're in the workplace, or is it really that you go to the HR department and say, we have some troubles here before I get raped or before it gets worse?
Yeah, you
How does that
report
work?
it. The first thing you have to do is report it. If there's an HR department, perhaps that's where you go. If you have a supervisor, perhaps that is where you go. But the starting point is reporting it to your employer so your employer has a chance to deal with it. And it's then how they deal with it that may or may not turn something into a case.
Are you always supposed to go to the employer first before you go running to the police? Or I don't mean to say go running to, before you go to a police and say, this is what this is and I want my justice and it needs to be in the court of law or whatever?
You should do both. One, to protect your rights as an employee, and the other so that justice is served.
And I read something that was kind of an interesting thing to me. So at some point, if you think that you're involved in a brouhaha, there's some value for you to get your personnel record as it is before any of this escalates, because after it escalates, who knows what's going to happen. Is there wisdom in that?
There is.
I don't know people who would necessarily think of that.
Right.
Worth to share.
There is, because one of the concerns you might have is once you start complaining, they're going to start putting things in your record that show you are a complainer or that they've had other issues with you that weren't in there before. So it can be very helpful to have a copy of your records.
And this should go on whether you were involved with a cohort or your supervisor. Is that correct? It doesn't matter either way?
Any situation where there's an issue at work that you're concerned about.
And in terms of HR policy, are you supposed to be reading that book before you go to see HR, or is it just, I've been the victimized person, please take care of me? Do you have to know your rights and be well versed in this before you go and report something?
Well, if you do have a handbook, it's not a bad idea to go through it so you can make sure I am following the appropriate chain of command that my company wants me to follow.
And both can mean suits, both for the employer as well as the victimizing supervisor. Can both of those things escalate
There's
to
a
that?
couple of different issues that can arise with that. Certainly your employer, if they don't do anything to take the right steps, then there's a claim against them. Hostile work environment, whatever it is of that type of nature. As opposed to the co-employee, there could be a criminal case against the co-employee, and whether there's a civil case or not, we'd have to take a look at the facts really closely and make sure we're not having a workers' compensation situation, but rather a claim that wouldn't be covered under workers' comp and therefore can be brought under common law civil case.
Wow, we've certainly covered so much information. We hope that this has been helpful to you, hope that it helps you avoid any kinds of similar situations. We appreciate that you've tuned in to The Law Matters. Stay tuned because the law matters to you.